Okay, welcome viewers. This is episode 2 of The Question Australian Women Were Never Told to Ask, Transgender Legal Protection, Women's Sex-Based Rights and the Courtroom Reality Check. You can look at episode 1 for a recap. Part 1, I did the introduction. This is part 1. The first fact must be stated plainly. Since 2013, gender identity has been a protected attribute under the Federal Sex Discrimination Act. Now, there's people that argue that, and you can argue it all you like. The courts will defend it. The amendment was not merely symbolic. It created a legal basis for complaints where a person alleges discrimination because of gender identity. The Australian Human Rights Commission, as we've seen in the Senate estimates and all the rest of it, to our shock, as this thing's manifested, Rights Commission explains that people can make complaints if they believe they have been discriminated against on these new grounds, and that the protections apply in many areas of public life. Now, this means women must not enter the debate believing transgender legal protections are merely activist claims, institutional preferences, or political talking points. They are statutory protections. They exist in law. They can be pleaded in court. They can be relied upon in complaints. They can affect outcomes. And this is the first point of legal clarity. What I mean is, a woman who ignores gender identity protections is not arguing against an opinion. She's ignoring a legal reality. Point number 2. What the 2013 law actually added, and this was a case of suicidal empathy. There was no need for this, but Julia Gillard, in the state of mind she was in at this time, gave into it. And I think Julia Gillard was an atheist. If I am right, I apologise if I'm not, but I think she was. She wasn't a God-fearing woman. And that's how these viruses and things in the law get in. The 2013 amendment inserted new protected grounds into the federal sex discrimination framework. Those included sexual orientation, gender identity, and intersex status. The Parliament of Australia's bill summary states that the amendment provided new protections against discrimination on the basis of a person's sexual orientation, gender identity, and intersex status, and you can look up the Parliament laws to clarify that. And that means the law expanded. It expanded. It did not merely continue the prior structure. It introduced additional legal categories into an act that already protected sex, pregnancy, potential pregnancy, breastfeeding, marital or relationship status, and family responsibilities. But that was female specific. And now it's gone wherever way which it wants. And this expansion is the source of the latter conflict. Not because every expansion is automatically wrong, not because every protected group is illegitimate, but because every protected attribute introduces possible collision points with other protected interests. A mature legal analysis of all of this must ask, number 1, how do these categories interact? And I will say it is disintegrative. It's disintegrating. The more this clash goes on, the more enmity there is. And while the women are just saying, look, we want our privacies, the transgender groups are becoming more violent and vicious. And that's the parasitical virus side of it. That's why this kind of immorality was learnt not to be allowed into civilizations, because it has been, this isn't new. Look up history where this stuff infiltrated societies in the past. Sodom and Gomorrah. Why do you think the Lord torched Sodom and Gomorrah? They let it go. They just let them go, until the whole civilization was destroying itself through manifest immorality. This is just a micro incremental view into where this can all go. All right? Where do they overlap? Where do they collide? Which exemptions apply? Which purpose governs? Which harm is recognised? Which boundary remains lawful? And these are legal questions, not slogans. This is what you're up against. The 2013 amendment did not merely add words, it added collision points which in their suicidal empathy did not see coming. Right? And it's been coming for over a decade, for 13 years. It's just now manifested at the expense of females that have decided, I'm going to go against this. Okay, but going against it in the courts is brutal, because the courts are confined to the justices around these laws, not the morality, the application and execution of the rights of these laws. Part 3. What women's sex-based protections were built to protect. Let me say that again. Part 3. What women's sex-based protections were built to protect. Women's protections did not emerge from sentiment alone. They emerged because female embodiment mattered in public life. Sex-based protections historically related to real-world conditions: female bodily privacy, pregnancy, maternity, sexual vulnerability, sex-based disadvantage, safety, fairness, and equal participation. And this matters because women's protections are not merely identity claims. They are tied to biological sex and its consequences. Female-only spaces exist because they are a context where biological sex matters. Female sport exists because sex may matter to because sex matters to fairness. Female refuges exist because sex may matter to trauma, vulnerability, and safety. Female prisons exist because sex may matter to risk, privacy, and power. Female intimate services exist because bodily privacy matters. And female association exists because women may have legitimate reasons to gather as women. And this is the counterweight in the legal debate. Women are not asking for sex-based boundaries merely as personal preference. They're asking whether sex-based boundaries remain legally meaningful when gender identity is also protected. What I mean by this is women's rights do not become imaginary merely because another protected attribute exists. Point number 4. The central collision point. The central collision point. The conflict does not appear in every setting. It appears where access to a sex-based boundary is disputed. The courtroom collision usually takes its form, and it will take this form on: a person asserts gender identity protection. A woman, organisation, service, business, or institution asserts sex-based boundary protections. And the legal system must then determine whether the exclusion, distinction, condition, or policy is unlawful discrimination or a lawful sex-based measure. Now, okay, let me just use a general scenario. Okay. Say, for instance, I'm running a bricklaying team and I can only have men. This job's severe, it's brutal, it's hard. I can't have women there, just out of experience. I can't have weak men. I can't have strong women. I've got to have fully experienced masculine men. Now, this is the vulnerability. If a man comes along and puts an application in that's a transgender, and I say, look, this isn't going to fit what we're up against, the brutality of what we're up against here, you're just not going to make it. And I've actually said this to normal bricklayers. In some cases, they just weren't going to make it. The problem that we've got now is these people can wipe you out. They can wipe your business out. They can rub you out in the court system. Are they coming for me? Who knows these days? Anyway, that's the problem that we're up against. So in the real world, I'm right. There's certain places that these people shouldn't put themselves. But in the court world, I'm wrong because it doesn't stick with the law. And you can't push back on that. Okay? You just can't. Money ain't going to beat it. It's just not going to beat it because they're going to hold the law. This is the precise point women must understand. The question's not, do trans people have rights? Yes, they do. The question is not, do women have rights? Yes, they do. The question is, when the two rights appear to conflict, what legal principle governs the outcome? What legal principle governs the law? And this is the question Parliament has not clearly resolved to the satisfaction of many Australians. In other words, it's the Parliament that's caused this, right? It's the Parliament that's inflicted these laws on the courts and the consequences of these laws on the women and other people. It's not the courts. The courts are bound by the laws given to them by the Parliament. And I'll get into that a little bit later. And so the question Parliament has not clearly resolved to the satisfaction of many Australians. We're confused. That's why I'm calling this therapy. Because this needs to be cleaned up. We've got people destroying their lives in the court system, coming out of there just completely traumatized, going, where's the morality in that? And the solicitors and barristers are going, oh yeah. They know what the outcome's going to be because they know the laws, but it's work, isn't it? It's a job. What you've got to realise is the court system is, and I've said this before, the cashier for the government. You come in, it doesn't matter. One lady won a case. Who was that lady that won the case? Somebody won a case. The other lady, the one that was arrested in COVID illegitimately, won the case and then had to pay a $250,000 court bill. In other words, we're going to let you win, but we're going to send you broke. When you go to court, you are going in, right? You might win your moral argument, but you're going to come out punished, even if you win. And God help you if you lose. How can you win a court case and come out with a $250,000 court bill Yeah, that woman was Monica Smith. Monica Smith won the case, and then now she's up reported anywhere between $200,000 to $250,000. That's 15 minutes. I'm Dr. JW Ayub. I'll see you in the next episode.